Oftentimes people say, well, why would I pay an attorney when I could just use a veteran service officer? One thing we do as an attorney is, and every attorney working for this firm, they do a comprehensive review of the case file, or the C file, the claims file. And that comprehensive review sometimes reveals what's called a clear and unmistakable error. General rule is you have 1 year to appeal a VA decision. However, a clear and unmistakable error is where the error is so egregious that if you had 10 judges lined up, all 10 judges would say, yeah, there was a mistake made there, and there's no room for disagreement. Reasonable minds can disagree, but when you're talking a clear and unmistakable error, no reasonable mind could disagree. 10 out of 10 people are going to agree that there is a misapplication of the facts to the law. It's a very high legal threshold to overcome. And for that reason, they're often denied. You have to allege with a certain degree of specificity the facts and law that you say the VA got wrong. We have veterans call us all the time saying, I just received 100% evaluation. I want to go back to 1970 when I applied for the first time. And unfortunately, that requires a clear and unmistakable error. So here's a hypothetical. A veteran goes and files a claim for right knee condition. And then the doctor says, no, this right knee condition today isn't what happened on active duty. You have an unfavorable medical opinion in 1970. Well, fast forward to 2016, the VA says, man, he did have quite a few injuries. They're going to schedule another medical opinion sometimes. And now this new doctor says, yes, what happened on active duty was likely what happened, a continuation of what he has today. So the new evidence is a new doctor's opinion. That evidence wasn't in the file in 1970. And so that wasn't a clear and unmistakable error in 1970 because you had an unfavorable opinion. You had to appeal that and procure a favorable medical opinion in 1970 if you wanted to date back to 1970. But in 1970, if you have unfavorable facts and then new facts come to light 20 to 30 years later, you can't go back to 1970. You had the right to appeal that in 1970, but if you didn't appeal it, and if the veteran sits on their rights, unfortunately, the threshold to go back to all the way back 30, 40 years is quite high, the legal threshold that you have to overcome. And it should be, because there has to be an end to claims. Veterans call us all the time saying, I want an attorney because I want to speed the process up. If an attorney tells you that we can speed the process up, run. Short of the veteran being terminally ill, or what the VA would call of an advanced age, or homeless, and maybe some unique exceptions outside of that, an attorney can't speed the process up. There's no law or mechanism even in place to allow an attorney to speed the process up.